You know the name Doug Poppa?
Yes, I do. God bless Doug Poppa, an honest cop.
I was elated, of course, but then as he testified, I was somewhat concerned for him, because I knew that they were probably going to crucify that man.
The top cop who put his badge on the line for justice.
One man who confronted truth and consequences.
Welcome to episode 42 of Truth and Consequences with Doug Poppa for Monday, April 5th, 2021. In episode 40, I addressed the civil action that was filed with the Nevada United States District Court against the Nevada Commission on Judicial Discipline by attorneys representing embattled Las Vegas Justice Court Judge Melanie Andress-Tobiasson. If you recall from episode 40, I pointed out numerous false statements, inconsistencies, and omissions that were contained in the lawsuit that was filed by Tobiasson's attorneys, to include false accusations made against me, an independent investigative journalist. With that said, in my next podcast, episode 43, I will continue with my analysis of the Tobiasson lawsuit against the Judicial Commission, and yes, once again, address further false statements, inconsistencies, and omissions in the Tobiasson lawsuit. Based on information and belief, Judge Tobiasson and others associated with Tobiasson have engaged in a pattern of slander, false accusations, and attacks on my credibility, character, and professional experience with various persons in the Las Vegas area for well over 2 years. Right now, I'm going to read excerpts from a letter that was addressed to Nevada Assemblyman Steve Yeager, chair of the Assembly Judiciary Committee, on January 25, 2021, by Paul Daly, Executive Director and General Counsel of the Nevada Commission on Judicial Discipline. The entire letter is available on the screenshots in this podcast, and I have included a link in the comments section of this video to the Nevada legislator for further information. Dear Assemblyman Yeager, I am the Executive Director and General Counsel of the Nevada Commission on Judicial Discipline. The Commission is comprised of district court judges, attorneys, and lay citizens appointed by the Nevada Supreme Court, the State Bar of Nevada, and the Governor, respectively. I am writing this letter to you and each of your fellow colleagues on both the Assembly and the Senate Judiciary Committees on behalf of the Commission regarding Assembly Bill 43. If enacted into law, this bill would further the never-ending efforts by some among the proponents of AB 43 to besmirch the Commission by propagating false narratives, weaken its constitutional and statutory authority to protect the public, as well as to construct countless obstacles in the path of the Commission, which will make it more difficult and time-consuming for it to effectively address the judicial misconduct in Nevada. Such efforts, if not blocked, would significantly impact the administration of justice and cause harm to the public, your constituents, on a statewide basis. AB 43 was submitted for filing with the Nevada legislature by the Nevada Judges of Limited Jurisdiction, NJLJ, which is a domestic nonprofit cooperative corporation whose members consist of justices of the peace and municipal court judges throughout the state. This bill is not supported by the Commission and many others, including those among the judiciary, for many of the same reasons set forth below. If you recall, the NJLJ submitted a similar bill, AB 20, and related amendments during the 2019 legislative session, which was rejected in its entirety and failed to pass the Assembly. It should be noted that citizens across this country are becoming increasingly fed up with judicial misconduct. The prevalence of these sentiments has increased at an alarming rate over the last few years alone. So much so that both state and national public interest organizations and advocacy groups, particularly those focused on low-income and minority communities where judicial misconduct has had such a devastating and disparate impact, have taken notice. These organizations and groups, together with nationwide media organizations, have begun to heavily scrutinize, investigate, and focus their attention and financial resources on not only judicial discipline commissions throughout the country, but also individual legislators and state Supreme Court justices for the appearance of going, quote, soft, unquote, on judicial misconduct by virtue of non-existent, non-transparent, and/or, quote, slap on the wrist, unquote, discipline, as well as for legislative bills/laws and state Supreme Court opinions that seemingly enable such circumstances to continue. As an illustration of this trend, enclosed for your review are copies of two recent Reuters articles circulated nationwide entitled, quote, "Thousands of U.S. judges who broke laws or oaths remained on the bench," unquote, and, quote, "With judges judging judges, rogues on the bench have little to fear," unquote, published on June 30th, 2020 and July 9th, 2020, respectively. This is just the tip of the iceberg. Accordingly, this is not the time to weaken the Commission by entertaining unconstitutional and ill-advised bills, such as AB 43, which only seek to impede, obstruct, and delay the Commission's ability to meaningfully and timely address judicial misconduct in Nevada. Certain proponents of AB 43 and others who have conveniently decided to jump on the bandwagon have been attacking the Commission for years under the mistaken belief that the Commission is, quote, out to get, unquote, justices of the peace and municipal court judges. These attacks on the Commission, which unfortunately extend to Commission staff, individual commissioners, investigators, and prosecuting officers, have formed the basis of a false and malicious narrative to undoubtedly manufacture a crisis where none exist. This narrative has been propagated and actively promoted over the years by some among the proponents of AB 43 in numerous case-related pre-hearing motions before the Commission, writ petitions, and appeals before the Nevada Supreme Court, as well as to carefully selected media outlets, self-proclaimed reporters, and/or, quote, friendly, unquote, bloggers, and no doubt to many among the judiciary and members of the Nevada legislature. It may come as a surprise to you, but over 90% of the complaints filed with the Commission are dismissed on jurisdictional grounds based on the discretionary decision-making of a judge. In other words, complainants who do not agree with the judge's decision, which are required to be dismissed by law, subject to certain enumerated exceptions. This dismissal rate is consistent with every judicial discipline commission in the United States. Consequently, a relatively small percentage of cases advance to an investigation during the judicial discipline process, and even smaller percentage result in formal public charges. Hardly a crisis. There is an overwhelming majority of highly qualified, competent, and respected judges at all levels of the judiciary throughout Nevada, all for whom the Commission, its staff, investigators, and prosecuting officers have profound respect and admiration. The honor and integrity of these judges and the Nevada judiciary as a whole should not be allowed to be compromised or tarnished by the likes of a few malcontents and conspiracy theorists touting a false and stale narrative that has, quite frankly, been repeatedly recycled among state legislators and courts throughout this country for decades. Very well said, in my opinion, Mr. Daly. Now I will read a letter that was addressed to Nevada Governor Steve Sisolak on March 3, 2021, sent by Paul Daly. Dear Governor Sisolak, I am the Executive Director and General Counsel of the Nevada Commission on Judicial Discipline, a judicial branch agency. You recently received a letter dated February 22, 2021, from Mark P. Cook, Esquire, of Cook and Kalisis, Limited, which was copied to the Governor's Finance Office, the Budget Division, as well as numerous chairs and vice chairs of several legislative committees, as further set forth on the last page of this letter. I will not be responding to Mr. Cook's groundless attacks against the Commission, which have all been rejected to date by the Commission, the Nevada Supreme Court, and the Board of Governors of the State of Nevada. However, I believe that a response is appropriate and necessary under the circumstances, since Mr. Cook seeks to undermine the Commission's pending budget request before the Nevada legislature for critical resources, staff, and budgetary funds, as well as influence in concert with certain proponents among the Nevada Judges of Limited Jurisdiction, the NJLJ, the passage of an unconstitutional and ill-advised bill, Assembly Bill 43, currently pending before the Assembly Judiciary Committee. In order to put Mr. Cook's letter into perspective, you should know that Mr. Cook is current defense counsel for Judge Andress-Tobiasson, a Las Vegas justice of the peace, in a very litigious and contentious judicial misconduct case which has been ongoing for several years before the Commission and the Nevada Supreme Court. A public disciplinary hearing involving Mr. Cook's client, Judge Andress-Tobiasson, is currently in the process of being rescheduled before the Commission in the above-titled matters, which should take place in the coming months. While I cannot comment on Judge Andress-Tobiasson and the public charges filed against her, I have enclosed for your convenience and review, in the event you wish to be informed of the big picture, copies of the formal statement of charges filed against Judge Andress-Tobiasson on August 31, 2020, the Commission's answering brief to Mr. Cook's petition for writ of mandamus and prohibition, filed with the Nevada Supreme Court on October 9, 2020, which responds at length to Mr. Cook's unsubstantiated attacks and allegations against the Commission, as well as the Nevada Supreme Court's order denying Mr. Cook's petition for writ of mandamus and prohibition in its entirety, filed on November 20, 2020, all of which are public documents. It is also important to note the sheer lengths to which Mr. Cook has gone to attack the Commission and continue his assault on virtually everyone involved in his client's disciplinary case before the Commission, including 1. Individual commissioners comprised of judges, lawyers, and laypersons appointed to the Commission by the Nevada Supreme Court, the Board of Governors of the State Bar of Nevada, and the Governor's Office. 2. Commission staff. 3. Independent and professionally licensed Commission investigators. 4. Each of the Commission's prosecuting officers who are independently licensed Nevada attorneys, as well as 5. Members of the public. 6. Complainants, and shockingly, 7. Even those who have agreed to be witnesses at Judge Andress-Tobiasson's upcoming disciplinary hearing, including, but not limited to, members of the press, the Las Vegas Metropolitan Police Department, and the Clark County District Attorney's Office, among others. In addition to Mr. Cook's ongoing assault on the Commission and all of the participants/witnesses in his client's upcoming disciplinary trial, as well as the long-standing constitutional and statutory processes that govern judicial disciplinary hearings before the Commission, Mr. Cook has relentlessly employed and continues to engage in the following scorched earth tactics, including, but not limited to, 1. Threatening to file attorney discipline complaints with the State Bar of Nevada against me as General Counsel and Executive Director of the Commission, as well as the Commission's prosecuting officers for pursuing and prosecuting the Commission's disciplinary case against his client. 2. Serving and/or attempting to serve subpoenas on the spouses and co-workers of certain Commission investigators who have nothing to do with the Commission's disciplinary case against his client. 3. Commission prosecuting officers from prosecuting the Commission's disciplinary case against his client. 4. Seeking to disqualify and remove each of the individual commissioners scheduled to be hearing panelists during his client's disciplinary hearing, including a judicial colleague of his client serving on the Commission. 5. Seeking to disqualify and remove certain prosecuting officers from prosecuting the disciplinary case against his client only a few weeks or months prior to the commencement of the hearing by requesting meetings before the Board of Governors of the State Bar of Nevada, one of the Commission's appointing authorities, on matters that have already been litigated, despite previously withdrawing and waiving any objections to these very same matters. 6. Attempting to undermine the Commission's budget requests for critical funds, resources, and staff before the Nevada legislature by fabricating meritless allegations which not only have been previously rejected by the Nevada Supreme Court and the Commission, but are belied by Mr. Cook's own actions, which have had the intended effect of depleting the Commission's small budget prior to the upcoming disciplinary hearing against his client. And 7. Submitting overly burdensome public records requests under NRS Chapter 239 for documents and information which are not only already in the public domain, but also have been previously accessed by Mr. Cook and attached to his legal filings with the Commission and the Nevada Supreme Court. Despite the Commission's good faith compliance with Mr. Cook's public records request, Mr. Cook continues to threaten to file a civil lawsuit against the Commission for its refusal to provide confidential and privileged materials which are prohibited from being publicly disclosed by law. To make matters even worse, the most troubling of Mr. Cook's actions involve threatening to individually sue and actually serving litigation hold letters to the personal residences of each of the following individuals. Number 1, the General Counsel and Executive Director of the Commission for pursuing on behalf of the Commission a disciplinary case against his client. Number 2, each of the commissioners, comprised of judges, lawyers, and laypersons, serving on the disciplinary hearing panel involving his client, including a fellow judicial colleague of Judge Andress-Tobiasson serving on the Commission. 3, the Commission's independent and professionally licensed investigators for being involved in and investigating his client on behalf of the Commission. 4, the independently licensed Nevada State attorneys serving as Commission prosecuting officers for prosecuting the case against his client on behalf of the Commission, as well as, astoundingly, 5, several members of the public who have agreed to participate and testify as witnesses during the Commission's disciplinary hearing involving his client, including those who filed judicial misconduct complaints against his client, as well as members of the press and others, including, but not limited to, those among the Las Vegas Metropolitan Police Department and the Clark County District Attorney's Office. In closing, I would like to point out that Mr. Cook's pending case before the Commission is just one Commission case out of the hundreds that the Commission receives on a yearly basis. It appears that Mr. Cook, by virtue of his February 22nd letter, has unwittingly but convincingly made the case for the Commission as to the precise reasons why it is vitally important for the Commission to receive its budgetary requests for critical funds, resources, and staff, thereby enabling the Commission to continue carrying out its constitutional and statutory mandates of protecting the public. Moreover, Mr. Cook has likewise provided the requisite justification and evidence underlying the Commission's opposition to the unconstitutional and ill-advised bill submitted by the NJLJ Assembly Bill 43, which should be rejected in its entirety. The Commission's mission of protecting the public and preserving the integrity of the judiciary far outweighs the self-interest of a few disgruntled limited jurisdiction judges. If you have any further questions regarding this matter, please feel free to contact me at your convenience. That letter was signed by Paul Daly. Reading from an excerpt of a footnote to the letter to the governor from Paul Daly, quote, "From the very outset of his representation of Judge Andress-Tobiasson to the present, Mr. Cook has leveled false and contrived allegations of bias, bad faith, conflicts of interest, recklessness, failure to follow the law, and other meritless collusion, collaboration, and secret Star Chamber conspiracy theories in proceedings and matters before the Commission, the Nevada Supreme Court, the Board of Governors of the State Bar of Nevada, the Governor's Office, and Nevada state legislators. My closing comment. Judge Melanie Andress-Tobiasson is wealthy. Her family is well known and influential in the state of Nevada. Judge Tobiasson has the monetary means, as she has proven thus far, to file meritless motions in the court. I would have to ask this question. If Judge Tobiasson has done nothing wrong, then why doesn't she stop wasting our taxpayer money and proceed to the hearing so the truth can be told? You know the old saying, if you have no defense, dazzle them with bullshit. Guess what? One of those litigation hold letters that Mr. Daly addressed in his letter? Well, I got one in the mail. Mr. Cook and Mr. Sheets, I have 4 words to you. Freedom of the press. You are not getting jack shit. I cut up that litigation hold letter in small squares, in case we have another shortage of toilet paper. That's it for this episode, folks. Stay tuned for episode 43, when I once again rip apart Tobiasson's lawsuit against the Judicial Commission. Thank you.